Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drewer, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Santos-Zacaria v. Garland, which was argued before the court on January 17th. It's my honor to introduce our guest today, John Elwood. John is a partner at Arnold Porter, where he heads the firm's appellate and Supreme Court practice, and we're very happy to have him with us today. So thank you for joining us, John.
Thank you for having me.
And so I guess to start us off, can you give us a little bit of information about the background of this case, how we got here and why our listeners should care about the case?
Sure. So Santos-Zacaria versus Garland asks whether non-citizens must ask the Board of Immigration Appeals to reconsider alleged errors before seeking review in the federal courts of appeals. The courts of appeals disagree on the issue, and the Supreme Court's answer could significantly affect non-citizens facing deportation and the immigration court's tasked with hearing their pleas for relief. The case arose from the government's attempt to deport Leon Santos-Zacaria, a 34-year-old transgender woman and citizen of Guatemala. She was detained and applied for a type of humanitarian relief known as withholding of removal under the Immigration and Nationality Act. She also applied for protection under the Convention Against Torture and International Treaty. And although they're slightly different, I'll treat them as essentially coextensive because the differences aren't really relevant to the legal issues before the Supreme Court. But under the INA, a withholding of removal application must show that they are likely to be persecuted in the country to which the government will send them. The presiding immigration judge at her initial hearing the IJ must presume that the applicant will be persecuted in the future if they show that they were previously persecuted because of their membership in a protected group. And being LGBTQ is one such group. Under both the INA and the Convention Against Torture, the government can rebut the presumption by showing that the applicant's life or freedom would not be threatened in the removal country due to their membership in a protected group. The government can rebut the presumption by showing that the applicant can safely and reasonably relocate to any part of the removal country. That's another way of doing it. In her hearing before the immigration judge, Santos-Zacaria alleged that she was persecuted in Guatemala for being transgender. She asserted that she was raped as a 12-year-old, that she was threatened with death if she did not leave the community. She said that she was ridiculed and threatened. The immigration judge denied Santos-Zacaria's application and reinstated her deportation order. The judge said even if true, her allegations were insufficient to establish past or future persecution under the INA. Now, that brings us up to the Board of Immigration Appeals, which is the administrative appeals body in the immigration process. On review, the Board of Immigration Appeals ultimately affirmed the judge's decision, but on a very different basis. The BIA rejected the judge's conclusion that Santos-Zacaria had not been subjected to past persecution as part of the LGBTQ community, and it instead held that she was both persecuted and that she was entitled to a presumption of future persecution. That said, the board also found that the government had successfully rebutted that presumption. It cited several reasons for doing so, including that Santos-Zacaria's rape took place a long time ago, more than a couple of decades, that she had voluntarily returned to Guatemala several times without harm happening to her, and also that even Santos-Zacaria recognized that there might be places in Guatemala to which she might safely relocate. So at that point, Santos-Zacaria appealed to the U.S. Court of Appeals for the Fifth Circuit, and there a divided panel upheld the BIA's decision. Now, Santos-Zacaria argued that the Board of Immigration Appeals based its presumption determination on facts that it was not permitted to find. Essentially, the BIA has to take the record developed by the immigration judge as it is and not add to it. And Santos-Zacaria argued that the IJ never reached the question that the Board of Immigration Appeals reached, and said that what it did was instead essentially tantamount to engaging in appellate fact-finding, which it wasn't allowed to do. At that point, a majority of the Fifth Circuit, with Judge Richman, then Judge Owen writing for the majority, and Judge Edith Brown Clement joining her, concluded that it lacked jurisdiction to consider that argument, and Judge Higginson dissented. They both said that Section 1252 D1 of the Immigration and Nationality Act states that federal appellate courts, quote, may review a final order of removal only if the non-citizen has exhausted all administrative remedies available to the non-citizen as of right, unquote. And under Fifth Circuit precedent, the non-citizen must give the BIA a chance to address its alleged mistakes, even if that means returning to the BIA immediately after it has issued a decision. And since Santos-Zacaria had failed to do that, had failed to say you must reconsider because you made an error that I haven't previously pointed out to you, that since she hadn't done that, that the Fifth Circuit had no authority under the INA to hear her claim.
All right, so thank you for taking us up to the Supreme Court. So I guess before the court, were there any kind of key takeaways from oral argument? Any highlights that you'd like to cover?
So as the case reaches the Supreme Court, there are two questions presented. Now, the first question is whether the statutory exhaustion requirement is jurisdictional. That is, whether it goes to the Fifth Circuit's authority to hear the party's claims, or whether it is just a so-called claim processing rule, something that ordinarily has to occur, but that can be waived or forfeited or overcome in various ways. The second question presented is whether Section 1252 D1's exhaustion requirement obligated Santos-Zacaria to submit her impermissible fact-finding claim to the BIA in a motion to reconsider before appealing to the Fifth Circuit. Now, Santos-Zacaria argues that 1252 creates a claim processing rule that the government waived in the Fifth Circuit because there's no dispute that the government before the Fifth Circuit didn't assert that there was any sort of waiver problem or any sort of failure to exhaust claim. And therefore, they essentially, the argument is that they waived or forfeited the argument to the exhaustion requirement. Now, in recent years, the Supreme Court has been trying to be much more disciplined about what requirements it calls jurisdictional. The term was kind of thrown around very loosely for decades. And now, even though it hasn't necessarily required using any sort of magic word jurisdiction, the Supreme Court in recent years has come close and essentially wants some sort of clear statement that a provision of law goes to the power of the court to hear the case. And whereas in the past they would use jurisdictional to mean all sorts of things, including claims processing rules and various other things like that, nowadays it basically only wants to say a provision is jurisdictional with all that comes with that, if it truly does go to the power of the court to review something. Because if a provision really is jurisdictional, that means that arguments can't be waived, that if the party has failed to exhaust, that it doesn't matter if the other side hasn't pointed it out, or if there are equitable reasons that would ordinarily excuse those sorts of things. If it goes to the court's jurisdiction, they have no choice but to basically dismiss the case and can't go forward. Now, the provision at issue here does not refer to jurisdiction. It doesn't use that word, nor does it delineate a class or category of cases the appellate courts are permitted to hear. And perhaps tellingly, Congress did use the word jurisdiction in a dozen other provisions of the same enactment. So there's sort of a negative pregnant here that if they meant it to be jurisdictional, they would have used the word jurisdiction. The government, on the other hand, argues that it does speak to the power of the court by restricting the power of courts of appeals to hear issues not exhausted in BIA deportation proceedings by limiting their ability to, quote, review, unquote, those claims. So as the case reached argument, both Justices Samuel Alito and Brett Kavanaugh questioned very closely whether Santos-Zacaria was basically arguing for a magic words requirement when the court has said in the past that it doesn't demand magic words. You don't have to just use the word jurisdictional. Santos-Zacaria, represented by Paul Hughes, said essentially, no, that's true. There isn't a magic words requirement. But in a circumstance like this, where they did use jurisdiction, where Congress did use jurisdiction in many other provisions, there is kind of a stronger understanding than you would usually be the case that they really should have used jurisdiction if that's what they meant. Also, several justices, including Sotomayor, Kagan, and Jackson, emphasized the weirdness, the incongruity of having a court's power to hear a claim depend on the actions of the litigant. Ordinarily, litigants don't get to determine the jurisdiction of courts. Congress does. I think that Paul Hughes for Santos-Zacaria did make some headway, arguing that the court's decisions in recent years differentiate exhaustion requirements from jurisdictional limitations. And indeed, he basically argued that in recent years, the court hasn't found exhaustion requirements to be jurisdictional. And I think it was very telling that the assistant to the Solicitor General who argued for the government, Yara Dubin, acknowledged that the Supreme Court had not found exhaustion requirements to be jurisdictional in any recent cases. I think one of the more telling things that might have happened was that Justice Kavanaugh suggested that the court should consider making an explicit rule that at least when we're dealing with exhaustion requirements, Congress needs to use the word jurisdiction when it means for a rule to be jurisdictional. That, while we might not have a magic words requirement in most instances for a provision to be jurisdictional, that when we're talking about exhaustion requirements, because those overwhelmingly are just claims processing rules, if Congress wants us to be jurisdictional, it has to use the word jurisdiction. And I think that that's an important point here, because Justice Kavanaugh is in the majority like 97% of the time. He has for years been the justice who was most often in the majority. And so, wherever he goes is very likely to be where the court goes. And so if he thinks that they may want to do that, that's pretty important. In addition, Justice Gorsuch also seemed inclined to say something similar because of how much courts have struggled with that in the past. That courts have so frequently confronted this issue of whether exhaustion requirements are jurisdictional, that this was really an instance where, to provide guidance to the lower courts, they really needed to say something. In addition, I think perhaps the most telling part of the entire argument was Justice Kavanaugh asked the assistant to the Solicitor General the hypothetical. Now, suppose you lose on the first question, whether this is jurisdictional or not. Should we answer the second question anyway about, whether the exhaustion requirement requires rehearing, rather than remand to the Fifth Circuit and have them address it in the first instance? And anytime you hear a justice who's in the majority a lot, ask the hypothetical of your opponent. Suppose you lose on question one. That's usually a pretty good indication that you are going to lose on question one, or that the other side is going to lose on question one. This has only happened to me a couple times in arguments, but every time it has ever happened, it is played out exactly as you would think it would. And the assistant to the Solicitor General said yes, that courts need the clarity, so the court should go ahead and answer question two, which I think is, ordinarily it's a fairly minimalist court, and anything that they don't have to answer, they usually don't. And in theory, they could remand to the Fifth Circuit and have them apply the, this exhaustion requirement, knowing that it's not jurisdictional. And they could hold in the first instance that, sure, there's an exhaustion requirement, but the government didn't assert it. We're going to hold that they waived it and therefore apply it. And instead, there's been at least the United States appears to have acquiesced in the idea that the court can go ahead and answer that question on their own. Moving on to the second question, whether exhaustion requires the parties to file a motion for reconsideration, Santos-Zacaria says it doesn't require one to file a motion for reconsideration. The language of the statute says you have to exhaust remedies you have as of right. And whether a body grants a motion to reconsider is discretionary, and it's certainly discretionary before the BIA, but pretty much in any court, whether they're going to grant a motion to reconsider is entirely discretionary. And as a factual matter, I will point out that the BIA very rarely grants motions to reconsider. The government argues, on the other hand, that everyone has a right to file a motion to reconsider. And that is enough to satisfy the as of right language. They have the right to ask for it, and the government says that's enough to make it a relief as of right, or at least a remedy that they have as of right. Justice Jackson argued that was contrary to common usage. The discretionary review is the opposite of review as of right. She used the example of the court's own certiorari jurisdiction, because everyone can file a petition for certiorari, but because between essentially 1% and 4% of those are granted, no one would ever say that that is a remedy that you have as of right. Justice Kagan wondered whether the government's rule would require immigrants to seek rehearing in every single case, since after all you're doing is asking for reconsideration, and you can always say, BIA, are you sure about that? And she suggested that would be a very, very in a jurisdictional, or I'm sorry, in an immigration system that is already overloaded. She was suggesting it might not make sense to require people before they head onto the Court of Appeals to routinely ask the BIA, would you please reconsider that? Because it would mean that much more kind of litigation that isn't going to go anywhere just to get their ticket to go onto the Court of Appeals. The government argued in response to Santos-Zacaria's argument that when the BIA was deciding an issue for the first time without really input from the immigrant, that they had to seek reconsideration. So in this case, because they were addressing an argument that hadn't been made by the other side and hadn't really been addressed by the parties, in a case like that, to exhaust a claim like that, you do have to seek rehearing. And the government was arguing that to try to answer Justice Kagan's argument that what you were talking about here would really require everyone as a matter of routine to seek reconsideration. Kagan responded to that by saying, look, it's reconsideration. Of course, you can always ask for it. And if they might reconsider, then the rule that you're advocating, the logical conclusion of that would be that you have to do that as a matter of course. Justice Gorsuch asked a bit hostilely how many rounds this might go on for if the board continued to make mistakes. And the fact that there was kind of the fact that it seemed so hostile did suggest that he didn't much like the government's proposed rule. But Dubin did have a decent answer for her. She said that immigrants only have one round of reconsideration available to them as of right. So even though I have actually seen people petition for panel rehearing and rehearing on bank like 3 times in a row when the court kept screwing up, the government argues here that they only get one bite at the apple. Paul Hughes, again for Santos-Zacaria, made the point that when Congress wanted parties to have to ask for rehearing as a matter of course, it said so explicitly. And the Congress did do that in, I think, the only place that I know of it. They require in petitions for review of the FERC, Federal Energy Regulatory Commission, if people want to proceed to the Court of Appeals, they have to ask for reconsideration as a matter of course. And any argument that isn't included in your rehearing or reconsideration petition cannot be presented to the Court of Appeals. And Hughes was again making sort of a negative pregnant argument here that when Congress wants to require people to seek reconsideration, it knows how to do so. And so when it doesn't say that, don't imply one on your own or don't infer one on your own.
All right. Thank you for that very detailed and interesting analysis of the case. So I guess that tees us up well to talk about your prediction of the outcome. I can kind of predict your prediction based on what you said about Justice Kavanaugh earlier, but I'll let you have the floor. So where do you see this shaking out?
Sure. At bottom, it does seem likely to me that Santos-Zacaria will win the jurisdictional issue. And I think the smart money is that they would win the second issue as well. I think the jurisdictional issue is very clear. The exhaustion issue might be more difficult because of the distinction which the government suggested between arguments that essentially that the parties didn't make previously, basically issues that the BIA decided sua sponte, that those have to be subject to reconsideration. So I think there's some chance that they might be able to eke out a victory on the second issue, but I think it's pretty clear Santos-Zacaria will win on the first issue.
All right, thank you for the prediction, and just in general about the significance of this case. What are your thoughts on that? Fallout from this, implications, etc. Feel free to
Sure.
to have at it.
Well, I think, this is important all on its own because there are just so many immigration cases. The volume of immigration cases, both before the IJs, the BIA, and the courts of appeals is huge. It's been, it was already big. It's gotten huge in the wake of 9/11. And this answers a very basic issue for immigration, or it will answer a very basic issue for immigration, whether exhaustion is jurisdictional and what exhaustion means. And because courts are loaded with immigration cases, it is important of its own right. And particularly if this eliminates the need for routine rehearing, that is the rule in about half the courts that have passed on the matter. And if that changes, it would be a pretty significant boon for the immigrant community. It may also rule, and if Justice Kavanaugh gets his way, it may rule that exhaustion rules are presumptively non-jurisdictional unless Congress explicitly says otherwise. And that is an issue of broader application because there are a lot of statutes that require exhaustion. And if the court says basically those are claims processing rules, they're not jurisdictional unless Congress explicitly says so, that will clear the way for a lot of those types of laws, even outside of the immigration context. Finally, there's this question, if the court does get to it, what exhaustion requirements mean and whether and under what circumstances they require rehearing. And certainly if the court adopts the most favorable reading to Santos-Zacaria, that forget about rehearing. You don't have to seek rehearing in order to exhaust your remedies. That will be a very clear rule that will help out a lot of people who are trying to head on to the courts of appeals or are trying to exhaust. But even if the court does say, if the body decides something sua sponte, you have to stop and at least ask them to reconsider that. If they do that, at least it will become clear. Although if they say that, I think there's a decent chance that that courts may be called upon to say, well, does that also mean the same thing in this review scheme? Because people may argue that it has different application in different contexts. So the breadth of this opinion remains to be seen, but it looks like it could be a reasonably broad opinion, at least on a few kind of nerdy issues.
Well, we certainly like nerdy issues on SCOTUScast. So I guess kind of closing us out, do you have any other things you'd like to talk about with the case or any general comments before we sign off?
Well, the only other remark that struck me as significant that I haven't talked about yet was Justice Alito said, what right do we as the court have to impose sort of a clear statement requirement on Congress? Like if they want to have things be jurisdictional, if they want to, say review, or if they want to say, to use a example that my old professor Guido Calabrese used to say, they could call it mustard plaster, and they could still make it be jurisdictional if they want it to be jurisdictional. But he asked, what is our authority for requiring that? And the answer that the advocate had, which I think it was Paul Hughes, was that it's a matter of implied understanding that, basically over the course of history, our reading statutes, we will presume that Congress will say jurisdiction when it wants it to be jurisdiction, because ordinarily they don't mean for something to be jurisdictional unless they say something like that, or at least they clearly indicate that they want the statute to control the court's ability to review an issue. But that with that one example, I think I have exhausted everything of interest from the argument. And the one thing I will note from this is that even though the court has a real propensity to go long, they sometimes go twice or even 3 times longer than the scheduled time for argument. This argument stayed at 1 hour. So it's an interesting case, but the Supreme Court is voting that it's not, twice or 3 times as interesting as the time allotted.
All right. I think that that wraps us up nicely. So, John Elwood, thank you for joining us today.
Thanks for having me.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.